So hello everyone, and welcome to our lecture recording for chapter 30. This is going to take us through criminal law in a business context, and you can find chapters 29, chapter 30 as well as chapter 23 on this website. So they are both online, as well as chapter 23. All these chapters are online. As usual, we're going to start with our learning objectives, and for this chapter they are on page 829. The first one asks us to identify the sources of criminal law and explain the contrast between civil and criminal law. So the first thing we want to point out on page 230 is that a crime is an offense against the state. So it's the task of the police to apprehend the person who's charged with committing the crime and prosecute them in a court of law. Now there are two types of prosecutors: a police prosecutor for minor cases, which will be in local or magistrates courts, or a state crown prosecutor, which will handle more serious cases that will be in the district court or the Supreme Court. Now always remember that there's an overlap between criminal acts and civil wrongs. So the commission of a crime will generally involve some type of offense against an individual and or their property, and will also attract civil liability, generally in the form of a tort. So as we said, this is of course our only chapter on criminal law, but criminal law of course is a complex area of law, and hence we will only restrict our discussions to broad principles of this area. Now, each state and territory in Australia has its own criminal legislation, including as well a Commonwealth legislation, which is the Criminal Code Act of 1995. You'll find that in the jurisdictions of Queensland, Western Australia, Tasmania, the Australian Capital Territory, the Northern Territory, these have codified their criminal law so that the common law has no relevance. This is of course in order to make the laws easier to find. Codification makes laws easier to find and more responsive to changes in community values than the common law. So it changes faster because it's something that's legislated through parliaments. Our last point to remember is that criminal codes and criminal acts do not actually cover every criminal offense. So you'll find that at the federal level, for example, sections in the Corporations Act of 2001, which is a Commonwealth Act, as well as the Australian Consumer Law, which is in the Competition and Consumer Act of 2010, these provide for criminal penalties. These provide for criminal penalties where the relevant acts are breached. At the state or territory level, breach of environmental protection legislation is a criminal offense, and conviction can carry a substantial fine. Let's look quickly at the differences between criminal law and civil law. So remember that in criminal law, the basis for criminal law is normally contained in the mens rea, or the mental element, which translates into the guilty mind, to commit a crime and the carrying out of an act called the actus reus. Okay? But note the following. First, not all conduct requires intention to amount to an offense. For example, there are crimes called strict liability crimes. Also remember that in some cases the same conduct can give rise to civil and criminal liability. So this is when we talked about torts, and as well things like assault or fraud. And that an increasing number of aspects of business conduct that don't fall within the criminal law carry criminal penalties. For example, breaches of occupational health and safety legislation, or breaches of environmental legislation, as well as breaches of the Australian Consumer Law, or the ACL. Now there's an in brief box on page 131 that looks at 6 dimensions and looks at the difference between criminal and civil legislation, rather law, in relation to these 6 dimensions. For example, who brings the cause of action? So in criminal law it's the state, while in civil law it's the individual. Who enforces judgment of the courts? In criminal law it's the state, in civil law it's the individual. The standard of proof in criminal law is beyond reasonable doubt, which is higher than the balance of probability standard that we find in civil law. The guilty mind or mens rea is required in criminal law but not in civil law. The onus of proof is the accused is presumed innocent until the state proves guilt. This is for criminal law, but in civil law the plaintiff must establish their case. And the punishment or remedy is that in criminal law it is a prison sentence or a fine. Sometimes it's also community service or loss of a license and so on. However, in civil law it's damages, so it's monetary compensation or sometimes injunction or specific performance which come from the equitable jurisdiction of the courts. Alright, let's then move on to our next learning objective, which asks us to summarize the main classifications of offences in criminal law. And the starting point is on page 831. We're going to look at two different classifications. The first talks about wrongs, threats, and statutory offences. And these are basically, this classification looks at the seriousness of these offences. So the first is wrongs against morality, such as murder and manslaughter and assault. The second has threats to the peace and good order of the community, for example, property crimes such as robbery, and statutory offences such as against laws directed at maintaining minimum standards of health, safety, and consumer protection within the community. Now, offences could also be classified into two different categories. The first is indictable, which again looks at the more serious offences such as felonies. These include things again as murder, rape, and robbery. And there are summary offences that are less serious. These include things like common assault or drunkenness and so disorderliness and breaches of statutory regulations. So these are called summary offences because they are triable summarily, so they are tried in a magistrate, unlike the indictable offences which come in front of a judge and a jury, although they also start from a committed hearing that starts from the magistrates or the local court. There's also a third category known as indictable offences dealt with summarily on page 832. These are cases usually involving loss or damage to property up to a certain monetary value. Most important thing in relation to these offences is that, as a general rule, the accused must consent to the summary hearing. And the idea is that you are gonna try these summarily because of things like efficiency gains, so you can do this quickly and cheaply, and usually will result in a lower penalty. So that's an incentive as well for the accused to accept such summary hearings. Alright, let's look at the third objective that asks us to explain the procedure and describe the elements and standard of proof required in criminal law. The first thing we want to talk about is the commencement of proceedings. Again, on page 132, you have criminal proceedings commence either by summons, which is an order to a person to appear at a certain court at a particular date and time to answer a particular charge, or arrest. So where a police officer makes an arrest and the person is subsequently charged and brought before a court as soon as is reasonably practicable, the arrest can be by warrant, where a justice of the peace or a judge directs a police officer to arrest a named person and bring them before the court on the charge set out in the warrant, or without a warrant, where the person is caught committing an offence. Then we have the idea of the indictable offences, committal and trial. So in the case of an indictable offence, a committal hearing takes place in the magistrate's court to determine whether there is sufficient police evidence against the defendant for the matter to be sent to trial before a judge and jury. The seriousness of the offence will determine whether the case is heard in an intermediate or superior court. Then you have the idea of a trial. The trial of an indictable offence will normally take place in a district court or a Supreme Court, depending on the seriousness of the matter to be heard. Jurisdiction is determined by the act that created the court. And then there are a number of stages I'll leave for you to have a look at. We will instead have a closer look at the elements of any crime. So in order for us to establish the crime, say it's murder or fraud or assault, embezzlement, whatever it is, we'll have to look at two elements. The first is the wrongful act or the actus reus, and the second one is the guilty mind or the mens rea. This may involve intention or foresight or knowledge or awareness. So notice the idea of mens rea is really related to that guilty mind, so it really relates to intention, but there could also be other guilty minds such as foresight or knowledge or awareness. Alright, there's a standard proof, as we said, and you can see that in the in brief box on page 833. The standard of proof is beyond reasonable doubt. However, in cases of a minor regulatory nature where the offense is one of strict liability, once the prosecution has established the offense on the facts, the onus shifts to the defendant to establish on the balance of probabilities that their actions fell within one of the statutory defenses. Alright, let's look at the fourth learning objective, which asks us to describe white-collar crime and illustrate with examples of some common white-collar crimes. So here we want to look at the definition of what a white-collar crime is. We know that a crime is an offense against the state. Here a crime is committed by a person inside a business, that's the key point, or government organization where the person takes advantage of their professional or clerical position in order to carry out the crime. There are a number of examples you can see on page 834 to 835. I will leave that for you to have a look at, and we will go and look at our fifth learning objective that asks us to list and explain some examples of statutory criminal law relating to business situations. So I'll leave these four examples of embezzlement, misappropriation, bribery, fraud, theft, robbery, industrial espionage, and sabotage for you to look at. They're really straightforward. You will also find three more on page 834, so 7 in total. You have money laundering, environmental vandalism, and computer-related crimes. Our learning objective, the fifth learning objective, starts on page 836 in relation to statutory criminal liability in business situations. Here we say, while most people connected with a business operation will be aware that there may be civil liability such as damages for breach of contract or negligence, they are probably less conscious of the possibility of criminal liability over and above the civil liability. So this is the key point. Sometimes there would be civil liability, but there would also be criminal liability over and above that civil liability, and you wouldn't be aware of it. So examples of this often unrecognized criminal liability are set below, and you'll find that we have things like under the Australian consumer law, consumer protection provisions. Okay, so there could be a fine. So this is a criminal remedy and may be imposed for any breach of the consumer protection provisions, except section 18 for misleading and deceptive conduct. So there is no criminal liability for breaches of misleading and deceptive conduct, so section 18, because it is recognized that the breach may occur unintentionally. Okay, but there would be also fines, so there would be criminal liability under the ACL under other sections, and you have an example, for example, under section 151. There's also restrictive trade practices provisions in the Competition and Consumer Act of 2010 Commonwealth. Okay, so I'll leave those examples for you to have a look at, but it will show you that there would be fines up to even $10 million, so very hefty fines, but that's why we say that there is this criminal liability. So criminal liability will attract, as we said, things like imprisonment, but also fines or community service and so on. So that's why we say that sometimes these are hidden criminal liability provisions that you should still be aware of in order for you to understand that criminal liability, civil liability sometimes will also attract criminal liability. The Privacy Act also talks about controls on the use of credit reporting information as well as other information acquired in respect of individuals, and failure to comply with the controls can result in fines of up to 2,000 penalty units for both government agencies and private organizations. Then there's the Financial Transaction Reports Act of 1988 and the Anti-Money Laundering and Counter-Terrorism Financing Act of 2006. Again, these will provide fines or impose fines and or prison terms for various types of non-compliance, including failure to provide information or providing false or misleading information and opening a bank account under a false name. So these are given to you on page 838. Alright, so this discussion is on pages 838 and 839, and you can see that there's also further discussion in relation to bankruptcy, the Bankruptcy Act of 1966 and so on. So I'll leave it to you to look at, and as well as to the summary of these liabilities in table 30.2 on page again 839. So let's then continue with the sixth learning objective in relation to the liability of a company, and this reminds us of what we discussed in earlier lecture recordings, which is the doctrine of separate legal entity. And this is our sixth learning objective, identifying examples of criminal law relating to companies and discussing examples of legislation under which civil penalties are imposed. So the starting point again is on page 140, drop to the fourth line. It reminds us that for a company to be directly liable for a crime, the court must attribute fault to the company. Okay. So the Criminal Code of 1995, the Commonwealth Code, makes companies liable, criminally liable, if A, there's a physical element of a statutory offence is committed by an employee, an agent, or officer of a company acting within the person's actual or apparent scope of employment or authority, and if intention, knowledge, or recklessness is an element of the offence, that state of mind will be attributed to the company if, first, company board or senior management tacitly or impliedly permitted or authorized the offence, or a corporate culture exists that encourages or tolerates the offence, or that the company failed to create or maintain a corporate culture or code that required compliance with the law. And there's further discussion of management of company. Individuals connected with management of a company may be liable for breaches of duties imposed by the Corporations Act. There are examples there, which you can also link back to page 810 in chapter 29. And there's also the issue of cyber crimes at the bottom of page 840, where it says the Cyber Crime Act of 2010 Commonwealth that amended the Criminal Code of 1995 creates offences for such acts as unauthorized access, modification, or impairment with intent to commit a serious offence, unauthorized modification of data, or unauthorized impairment of electronic communication. Then we have a discussion of civil penalties. So these are special type of statutory penalty. This is a pecuniary penalty, so you can link it to 504, page 504, so it's a fine. It would normally be imposed as a result of a criminal offence. So the court proceedings for a civil penalty are civil proceedings, that's why it's called civil penalty. So it's a fine, but it will follow a procedural approach that is really a civil proceeding, and that the rules of evidence and procedure are civil, not criminal. This means that proof of the breach is on the balance of probabilities, and it is therefore referred to as civil penalty even though it is intended as punishment. There is discussion under that of the National Credit Card as examples, and you will have also the Corporations Act of 2001 rather. So a civil penalty there may be imposed where an officer of a company has failed to comply with the act relating to the management of the company. You have examples there as well, and the section is relevant to that. And the last thing we want to talk about is really Spam Act. Again, similarly, you have civil penalties up to 1.1 million. The Australian Communications and Media Authority, the ACMA, has successfully launched a number of prosecutions against a wide range of businesses involving the sending of emails and SMS marketing messages, including well-known businesses, and they are listed for you on page 842. Okay, that brings us to the end of this lecture and to the end of our lecture recordings for this course. So chapter 30 is the last chapter we'll cover from the textbook, and we will start then our revisions in the following weeks. Thank you.